YouTube, it's Tone, back with another one for you. Uh, this one here, Cracking the Code 3, 18th installment of this particular book here. About halfway through this thing. So right here, we're going to get into a little bit of the glossary, uh, a little bit of information on what this whole process is about, what it's based on. Um, and then we're going to get into some definitions. And I'm gonna skip through some of the definitions. All of them are relevant, but I'm not gonna sit here and read every fucking one like that. So I'm gonna pick the most relevant ones, pertinent to the type of things that we do, like that discharge and things like that. So some terminology that you should definitely become familiar with. And if you need the book, let me know. I'll send it to you so you can check out the rest of the definitions on your own. A lot of this shit is crucial language that you're gonna need to understand in order to get things done properly. If you ever have to represent yourself or speak for yourself, you definitely want to know what you're saying and what the words mean, because words are everything, believe it or not. So let's get right into this here. So right here, cracking the code. So UCC means Uniform Commercial Code, per UCC 1-104. When there arises a conflict between current code and deleted section, the deleted section controls. Nothing is ever actually deleted. Therefore, earlier editions of the UCC would be useful. But they do switch the codes up and stuff like that. So, introduction. Do not expect to understand the UCC at a glance. And that's a fact. It took me a while to really grasp the concepts, and then, years to actually have the balls to move forward with anything at all, really. I did my UCC 1 ASAP, just like everybody else. When you first learn this information, you get this little bit of anxiety and panic, realizing that these motherfuckers tricked you the whole time, and you're like, what the fuck do I gotta do to get out of this? And I was like, damn, so what do I do? Right? So the first thing I did was the UCC 1 outlined in the one man out. I followed that process and shit. And so I sent it into to all the government agencies and things like that, putting them on notice and shit. And I never got anything back from them. So I don't know if they thought I was just, somebody who bought a package online or some shit like that. But I actually do this. Like, I actually study this shit. So, maybe they'll do their job one day. So it is the culmination of thousands of years of effort by countless collaborators and was never supposed to have been deciphered. It's true. They made it in such a fashion that it was just so much multifaceted fuckery that, like, you really... Like, you gotta have a broad view of this whole game in order to be able to put these pieces together. And a lot of people really only have tunnel vision. So, I'm blessed to have the mind that I have to be able to, pull the pieces together for everybody. So that's why I do this. So understanding the code can be likened to solving a giant jigsaw puzzle. And that's a fact. That's what I was just saying. So one is not going to see the picture with all the pieces in disarray. And they set it up like that purposely. So a few pieces must be connected before one can gain awareness of the fundamental issues at hand, build on them, and eventually solve the puzzle. But this need not take an inordinate amount of time. One good way to go about it is to follow the annotations accompanying the definitions, terms that direct you to see and compare other related terms in the glossary. And that's the thing, because a lot of the language that we use in the regular English language is not the same language that they use in the legal system. It's called legalese. It's literally a different language. So words that you think you know the meaning to do not mean the same thing when you walk into that courtroom. So by gathering bits of understanding from different places and from different points of view, the pieces of the puzzle begin to fit together and the big picture can take shape very quickly. There are a number of key terms that will provide a good entrance point to the glossary for gaining an understanding of the redemption process. Some of those terms would be straw man, birth certificate, transmitting utility, value, redemption, and House Joint Resolution 192 of June 5th, 1933. An entertaining and all-inclusive definition is found at The Wizard of Oz. And you know what it is. The Wizard of Oz. Land of the Lost. Neverland. So do not be daunted by the size of his glossary. All terms have bearing on what has happened and is currently happening, thereby making it very interesting material for anyone concerned about survival and freedom. And that's what I was just saying too. All of the definitions are absolutely crucial to understand. So I would highly suggest taking the time and reading them and getting to know them well, because you're going to need them if you ever got to put documents together or whatever. So here we got the glossary. So ab initio, and you're gonna see this on when you're doing your UCC1 and things like that, because this is when you go in and claim all the the credits for your straw man and things like that. When you're doing contracts and speaking in past tense like retroactive, right? Ab initio is going to be from the beginning, from the first act. Okay, so absolute rights as regards right to interfere with contractual obligations of another. Absolute rights, which individuals may exercise without reference to move our rights. Incidents to ownership of property rights growing out of the contractual relations, and right to either to enter or refuse to enter contractual relations. So that's a right that you have, is to the contract unlimited, not only granted by the creator but also by the Constitution as well. And so with that said, you also have the right not to enter into a contract with whoever you want by absolute rights, okay, of individuals. By the absolute rights of individuals is meant those which are in the primary and strictest sense, such as would belong to their persons merely in a state of nature, in which every man is entitled to enjoy, whether out of society or in it. The rights of personal security or personal liberty and private property do not depend upon the Constitution for their existence. And that's a fact. Obviously, there was something before the Constitution, and it was called nothing. You know what I'm saying? So it's basically a contract and the concepts that men put together. You know what I'm saying? And you know how that goes. So they existed before the Constitution was made or the government was organized. These are what are termed the absolute rights of individuals, which belong to them independently of all government, and which all governments can derive their power from the consent of the governed. Okay, so they need your consent for them to govern you. They may try to trick you and have you believe otherwise, but everything is voluntary here. Okay, otherwise you violate your free will, whatever that is. So instituted to protect. Acceptance, right? Private bankers, acceptance, A4V, things like that. Acceptance is going to be key here too. So this is one of the terms that I wanted to focus on too as well. So the voluntary act of receiving something or agreeing to certain terms. In contract law, acceptance is consent to the terms of an offer, creating a binding contract, the taking and receiving of anything in good part. And if it were a tacit agreement to a preceding act which might not have been defeated or avoided if such acceptance had not been made. The act of a person to whom the thing is offered or tendered by another, whereby he receives the thing with the intention of retaining it, such intentions being evidenced by a sufficient act. Okay, so what they're saying is that there's different ways that you can accept a contract or enter into a contract with these people, and one of them is by just accepting their offer, which sometimes comes in the form of a summons or things like that, but really they're all just offers, right? That's right, because if they could really just make you come in, then they would do that, but they're going to send you a summons with a date on it and expect you to reply and things like that. So they're trying to get a tacit agreement from you by silent acquiescence, by when you take it and just shove it in your drawer and think that you have to go. Well, guess what? Now you have to go. You know what I'm saying? So things to keep in mind. So this is Black 6. An agreement either by express act or implicit from conduct to the terms of an offer, so that a binding contract is formed. If an acceptance modifies the terms or adds new ones, it generally operates as a counter offer. So you can send them something back with your own offer, a counter offer, you know what I'm saying, things like that. You can send a reply back with an invoice, you know what I'm saying, because your time is valuable as well. You don't have to entertain these people for free at all. You know what I mean? A negotiable instrument, especially a bill of exchange that has been accepted for payment. All right, okay. Negotiable instrument, especially a bill of exchange that has been accepted for payment. So, negotiable instrument. So that would be when they send you a bill or something like that, right? Or like a traffic ticket or something like that. It's negotiable. Because if it isn't negotiable, then that would mean that it's a dictatorship and that you're making demands and you can't force anybody to do anything. So these are all really just offers. Acceptance by silence. When the court implies a promise or holds that good faith requires the party not to violate these expectations, it is recognizing that sometimes silence says more than words, and it is understanding its duty to the spirit of bargaining is higher than its duty to the technicalities of the language. So you can silently acquiesce, which these courts and, the governor, the Supreme Court, like when you start sending in your contracts, they're gonna silently acquiesce because the people are the government. Okay, so it's not even a question. These people all signs oaths to to whatever constitution that they sign it to. So you're calling them out on that, and everything that we do is all based on that. It's all based on your constitutional rights. So if they sign an oath to uphold it, then when you let them know and put them on notice that you're going to be exercising your constitutionally guaranteed rights, and you give them an opportunity to rebut it if they have a problem with that. But if they do rebut it, that means that they need to go get a new job, because you're violating your own oath at that point, right? Which is going to make you, a criminal at that point. It's treason and all that. Okay, definitely breach of contract, if nothing else. Okay. So, excuse me, breach of trust. You know what I'm saying? Because they're all entered into the trust when they sign on to uphold that constitution at the trust. Acceptance for value. Remedy, acceptance, value, holder in due course, banker's acceptance. That's the A4V, okay? The private banker's acceptance. So by acceptance for value is implied a taking and acceptance of something in exchange for another thing previously provided, using credit balance previously established to purchase something, which is value, as particularly defined within the UCC as an esoteric term. It implies that some sort of credit has been established beforehand, whereby the party with the credit may take, accept, purchase some item in commerce based on his credit, what is owed. It applies in some items in commerce based on his credit. It applies in numerous types of situations. Basically, if a party has established his position as a creditor of some sort, he can unilaterally accept, purchase, take anything that would such help reconcile the credit discrepancy by executing that particular transaction. Such a creditor, having essentially a credit balance, need not obtain anyone's approval before so acting. One example of this is the acceptance for value of a document bearing the creditor's trade name, the birth certificate, and all that, right? So that would be like a indictment or something like that, right? Which is a freaking negotiable instrument as well. That shit is all monetized. They turn it into bonds and they sell it on the market, trade it. They do what they do with it. Negotiable instruments. So you can A4V an indictment as well. So, according to UCC, right? Adhesion contract. Right, so there's different types of contracts. There's implied contracts, adhesion, express contracts, a few different ones. I think there's 4 or 5 different ones. So a contract so heavily restrictive of one party, while so non-restrictive of another, that doubts arise as to his representation as a voluntary and uncoerced agreement, implies a grave inequality of bargaining power. The concept often arises in the context of standard form printed contracts prepared by one party, submitted to the other on a take it or leave it basis. The law has recognized there is often no true equality in bargaining power in such contracts, and has accommodated that reality in construing them. Adhesion contract essentially would be like, based on your actions or things like that. Implied would be the same as well. So a driver's license application and an IRS form 1040 are examples of an adhesion contract. All right, so you enter into a contract to a certain degree, and then you get sucked into, some other shit. And so yeah, driver's license actually would be that, right? Because then what they say at that point, when you forfeit your God-given right in exchange, or you forfeit it in exchange for a privilege, then essentially that's putting you on the hook to become surety for the national debt, by them being able to tax your income, right? And then you want to get into the definition of income. What is that, right? So that's another example of words that we commonly use that mean one thing to us, out of like Webster's dictionary, that means something totally different when you go into their copywritten codes and policies that they use and enforce on people, right? So admiralty. A court which has a very extensive jurisdiction of maritime causes, civil and criminal. Admiralty law, maritime. So admiralty courts, municipal courts, superior courts comprise the only jurisdiction that can enforce a criminal penalty for a civil offense. And so that's what you got to understand too, is that if there's no victim, it's really civil in nature ultimately, and they're just trying to sell it as something else, when really it's just civil in nature. There is no victim. So no other type of jurisdiction has this capability. This is why people must post bail prior to arraignment, right? Guilty before proven innocent. Guilty before proven innocent. Welcome to America. So admiralty law. The term admiralty and maritime are virtually synonymous, which means that they're the same thing, and they are. And it's all going to be based on contracts. So affiant, the person who makes and subscribes an affidavit. The word is used in this sense interchangeably with deponent. But the latter should be reserved as the designation of one who makes the deposition. So the affiant, that would be you when you make an affirmation and then say it under oath. Okay, so as relates to the redemption process, affiant is defined as the natural born flesh and blood sentient being whose name is designated in upper and lower case, the one's true name, in accordance with the rules of English grammar, who executes and signs an affidavit under oath. An affidavit, a written or printed declaration or statement of facts made voluntarily and confirmed by the oath or affirmation of the party making it, taken before an officer of authority to administer such oath. Blacks first, see note, commerce. So no, the capacity to issue one solemn declaration of truth, one sacred word, is the most basic, fundamental, underlying, foundational concept of all commerce, society, and civilization. An affidavit is a written statement under oath executed and sworn to before an authorized officer to the maker's commercial liability, that in assertions contained within the affidavit are true, correct, and complete, not misleading the truth, the whole truth, and nothing but the truth. An affidavit is the most solemn, unequivocal, and ceremonial means extant to express truth without evasion, concealment, deception, or insincerity. As distinguished from testimony, an affidavit is not subject to cross-examination and is intended to be a complete, self-contained document. All truth is subjective, and yes, the fuck it is all, because there's your side, there's their side, and then there's the actual truth, right? So, and only each free will being possesses the right, duty, privilege, and capacity to state the affiant's own truth in accordance with the unique nature, perspectives, and priority of the affiant. No one has authority nor the ability to state the truth of another, right? So don't let anybody speak for you, right? As per the maxim of law, the order of things is confounded if everyone preserves his jurisdiction, because truth is supreme in commerce. An affidavit is the most important document in commerce and stands as truth unless rebutted point for point by a counter affidavit signed and certified on the executing party's commercial liability as true, correct, and complete. And this is why you only want to have interactions with these people under the penalty of perjury, signed sworn affidavits, okay? Don't let, because these people will lie to you if you let them. Make them put their ass on the line. You're not, why would you be the only person putting your ass on the line? These people have zero liability fucking making things up in the courtroom because you're not making them you're not making them fill out an affidavit. And you'd be like, okay, so you guys have a lot of claims here. Which one of you people want to fill out an affidavit to the bullshit that you're saying is true? How many of you people were first-hand witnesses? You know what I'm saying? So who and why would you even be speaking in the courtroom? You guys are all just here spitting a bunch of hearsay out, expecting me to just ride with that. You're out of your mind. So not misleading the truth, the whole truth, and nothing but the truth. Exodus 20:16. The ninth commandment states, thou shalt not bear false witness against my neighbor. And this is what they do. They just go in there and start barking shit off, and none of them were even there. It's like, okay, so where's the cop and where's the victim? I'm here talking to, a dude in a black dress and a prosecutor that I don't even know. And you guys, and then a bar member over here, and you guys all work for the same team. Like, come on, bro, cut it out. So, the ninth commandment states, "Thou shalt not bear witness against thy neighbor." The Bible is especially harsh on those who bear false witness. Lies are weapons that are easy to utter, difficult, if not impossible, to undo when spread as rumors, and can destroy lives. People often act on what is told to them and kill or are killed on the basis thereof, without ever doing their own research. So such as by marching off to war, right? Believing the authorities, they believe in the narrative, they're going out there to thinking they're doing some patriotic act, and really they're out there fighting a bankers war and really just getting themselves killed for nothing. Or blindly obeying one's superiors is as wise an attitude in the field of words as an idea as it is concerning goods or services. For one's group official attempt to avoid the consequences of bearing false witness. So a little bit of the terminology here to start getting familiar with. We're gonna run down. I'm gonna skip through a few different ones, but they're all of them are crucial. So, but I'm just getting the ones that I think are the most relevant and the ones you really should know now. So that's why we're doing this. So it is a game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.